Mic check, mic check. 1 2 1 2. We back, Bonnie. I'm gonna be here all day. Telling you what. Now there may be a break when I gotta go take notes for one of these days, but y'all gonna. I'm about to get on somebody's nerves. I'm gonna be here all day. Hey, Miss Lady One, we're back. All right, I'll go ahead and get started. So, as you saw on the thumbnail, so this is the not the first one we read. This is the other one. The other letter slash email. This one came out, as you can see, October 16th, 2024. Ashleigh Merchant sent it via email to Miss Persifield, which is is she the clerk? She's I can't remember her title, but she's the one that sits beside the court reporter in Judge Whitaker's chambers, or not chambers, but her courtroom. So that's Miss Persifield with she has like the grayish bob hair thing. Okay. So anyway, this is a long letter. Miss Ashleigh Merchant had a lot to say about her client, so we'll go ahead and get started. Okay. It says this is regarding the state versus Williams et al. Issues with proposed testimony of Martinez Arnold. Dear Judge Whitaker, I represent Martinez Arnold, a former defendant in the above matter. I am submitting this letter in anticipation of Mr. Arnold's upcoming testimony. The state recently advised me that the state intended to call Mr. Arnold today, October 16th, 2024. Yesterday, I was advised that he will not testify today and will likely not be called for several weeks, but that they would try to let me know by next week. Mr. Arnold originally agreed to testify when he entered into his plea in December of 2022, now approaching 2 years ago. Mr. Arnold has kept in constant contact with me over these past 2 years to make sure that he would be available whenever the state might call him as a witness. The first time that I was contacted by the state about Mr. Arnold being called as a witness was on August 13th, 2024 by Adrienne Love. Ms. Love asked if I could not appear with Mr. Arnold if there was anyone who could serve as stand-in counsel for me. I informed Ms. Love that I was not willing to allow any stand-in counsel to stand with Mr. Arnold during his testimony, and I asked for Ms. Love to give me some general indication of when Mr. Arnold's testimony would be needed. On September 4th, 2024, the state told me Mr. Arnold was needed within the next few days. I immediately emailed Ms. Love and Investigator Long with the few dates for which I had leaves of absence on file for September and asked for the state to provide me with an anticipated time frame for when they might call Mr. Arnold to the stand. I received no response by email, but Ms. Love called my cell phone the evening of September 11th, 2024, and also sent a text asking me to reach out to Investigator Long about the timing of Mr. Arnold's testimony. And y'all know Love is good for, she received direct instruction from the judge before to email the attorney for Moontoon that same time. She was like, send him an email, request blah, blah, blah. And then Love the next day was like, oh, well, I texted him. So we do know she'll send a text instead of an email real fast. Good morning, y'all. Good morning. I responded to the same email chain, providing all the dates we were available and the few days that I was not available. Ms. Love indicated that she would be calling Mr. Arnold as a witness in September. So I wrote Ms. Love and the court about the 5 days for which I was on leave in September. Mr. Arnold was never called as a witness during this time, and no one from the state ever updated me on when Mr. Arnold might be called as a witness until last week. On October 8th, 2024, Investigator Long emailed me and copied Mr. Adam Abadi and not Ms. Love about Mr. Arnold's testimony. We were told Mr. Arnold would be called as a witness sometime mid to latter part of the week of October 14th, 2024. We were asked to meet so the state could give notice of his impending testimony. I provided a very detailed response advising the state that I could have Mr. Arnold testify beginning October 14th, 2024, and anytime through October 18th, 2024, and beginning again on October 22nd, 2024 through October 25th, 2024. Since Investigator Long had mentioned in his email wanting to provide notice of Mr. Arnold's impending testimony, I drafted my October 9th, 2024 letter to Ms. Love and copied all parties, including the court, to clarify that Mr. Arnold was not avoiding service of any subpoena and intended to testify if called as a witness, but that we just needed some accommodations such as notice to ensure that I was able to accompany him for his testimony as his attorney. On October 9th, 2024, Investigator Long emailed me that they would provide a date for Mr. Arnold's testimony within 48 hours. He also said that they would provide me with anything that the state wanted Mr. Arnold to review prior to his testimony and answer my question about whether the state intended on asking Mr. Arnold any additional questions that would involve his Fifth Amendment privilege and or a grant of immunity. On October 11th, 2024, Investigator Long advised that Mr. Arnold would be called as a witness on October 16th, 2024, but that they would keep me posted as the trial progressed. He also advised that Mr. Abadi would be responding about whether there were any prior statements the state intended to use to refresh Mr. Arnold's memory and whether the state intended to ask any questions outside the proffer he provided that might implicate immunity or Fifth Amendment concerns. In the interest of expediency and to avoid wasting the jury and the court's time, I previously had asked the state to send me any prior statements the state may wish to use during Mr. Arnold's testimony. So that's okay. I don't know if this was the original plan. It probably was not because Love was included in stuff and now she's not. But it looks like they are switching up that the examination of Mr. Arnold will be done by Abadi and not Love. After that last letter that Ashleigh Merchant sent, I'm not surprised that Love may not be the one questioning Mr. Arnold when he does finally get on the stand, because Ashleigh was not playing with that woman. It says on October 14th, 2024, I wrote Investigator Long and Mr. Abadi to confirm that Mr. Arnold was being called at 9 a.m. on October 16th, 2024, and to again ask about those two outstanding questions regarding prior statements and questions outside of his proffer. In response, today, October 15th, 2024, Investigator Long responded that Mr. Arnold's testimony would not be needed this week and that the state did not anticipate his testimony taking place in the next few weeks. He wrote further, I do not have a date certain as of now. Here's the thing. That's that crap too. Even if that's not his time, why can't the state go ahead and provide the prior statements that they will be asking him about to refresh his memory? Why, even if they don't have a date, why won't they give what's being asked for? They do that a lot. Hold on, let me see. Love expects her witnesses to drop what they have planned when she is unorganized with scheduling, then blames them for not being able to be there, uses those subpoenas as power. I agree, Bonnie. She should know Love loves to waste time. She knows. Ashleigh Merchant got her foot on their neck and in precise order. Right, Shavy? Right. Okay, it says, Mr. Arnold and I have now been on call since January of 2023. While we realize that trials are sometimes unpredictable, we have been available for the past 22 months. That's a long time. Now, moving into November of 2024, I am specially set for a jury trial the week of November 18th, 2024, and will be on medical leave beginning November 22nd, 2024. Given how other witnesses have been required to testify with stand-in counsel, okay, Woody, stand-in counsel, did somebody else? I can't remember who else. I know it's more than that, but Woody is the one that comes to mind. Mr. Arnold is very concerned that the state is purposefully delaying calling him to the stand so that he will be denied his right to have his counsel of choosing, the same counsel that negotiated and is familiar with the terms of his plea. I am kindly asking the court to instruct the state to advise me whether, in fact, it intends to call Mr. Arnold at all so that we can avoid any unnecessary waste of the parties and the court's time and resources. That is a reasonable request. If the state still intends to call Mr. Arnold as a witness, and to the extent the court can address potential evidentiary and privilege issues before they arise, and to expedite Mr. Arnold's testimony in the presence of the jury, I believe advising the court of the history with regard to Mr. Arnold's plea negotiations and plea agreement would greatly assist the court in ruling on potential issues. Go ahead and get them, Ashleigh. Get them, Ashleigh. Okay, factual and procedural history regarding Mr. Arnold's plea. In 2014, Mr. Arnold was charged in indictment, that number, to which he pled guilty to a misdemeanor and completed his sentence on February 29, 2016. In 2015, Mr. Arnold was charged in another indictment to which he pled guilty under the First Offender Act and completed his sentence and was discharged and exonerated on November 1st, 2021. Mr. Arnold was able to complete the foregoing sentences without a felony conviction on his record. Despite this, in 2022, Mr. Arnold was arrested and charged for these same two underlying criminal indictments in the current RICO indictment and held without bond in the Fulton County Jail. Despite having been able to successfully complete probation for both underlying offenses and move forward without a felony on his record, Mr. Arnold was nevertheless denied bond. Having little recourse, Mr. Arnold attempted to negotiate a plea in connection with the RICO indictment that allowed him to finally be released from the conditions at the Fulton County Jail. Notably, while the state and Judge Glanville both were unwilling to grant Mr. Arnold a bond, they were willing to let him be released on probation, provided that he provide testimony sought by the state. Mr. Arnold, however, was unwilling to make all of the statements that the state sought. So Mr. Arnold was again sent back to the Fulton County Jail to languish without a bond. After further and deliberate negotiation, the state agreed to accept the statements Mr. Arnold could swear to under oath and agreed to release Mr. Arnold on probation once he made those statements and agreed to testify for the state about those statements. Mr. Arnold agreed only to the specific statements set forth in his plea agreement, and he was very clear that he intended to retain his right against self-incrimination under the Fifth Amendment to the United States Constitution should any party seek to question him about any matters outside of the specific statements contained in his plea proffer. She's on point. I gotta give it. She's on point. On December 16th, 2022, Mr. Arnold entered his plea, which allowed him to remain on probation. A copy of the plea colloquy, I'm going to say colloquy, I don't know if that's how it's pronounced, is attached here too. Since the entry of his plea, Mr. Arnold has been in full compliance with the terms of his probation, for which reporting is set to terminate in December of this year. His probation is ending 2 months from now, y'all. The state has not suggested Mr. Arnold has not complied with the terms of his probation, nor could it. Also, as noted above, Mr. Arnold has been ready to testify within the confines of his plea agreement. Y'all, first of all, the background that she's providing tells me that this is what the state has done to any witness they want to testify in this RICO case, which we have seen. This is just now, it's just written in written down for us to see how it's going. But I think most of us suspected that's how it's going for anyone that did a plea agreement to this RICO. Also, Mr. Arnold, I would stay home. Don't drive, don't go anywhere, because I feel like the state could have additional police just looking at you for something, a traffic ticket, something. Just don't drive. I don't know if you can get away with that or not. But sir, don't do anything, because I feel like they are looking for you, especially if your probation ends in December. Oh my gosh, be careful. But I agree with everything so far that she is stating. I have to agree that is how I see the state operates as well. Back to the letter. Hey, Bama. Recently, the state called one of Mr. Arnold's co-defendants to testify pursuant to his plea agreement. This witness did not receive a grant of immunity for his testimony, and unlike Mr. Arnold, apparently did not retain his Fifth Amendment privilege when he entered into his plea agreement. Oh, shame on his attorney if he could have encouraged him to invoke his Fifth Amendment. After this witness testified, the state filed a motion to revoke his probation for what the state believed was a violation of the terms of his probation. The state alleged that the witness directly contradicted the special conditions of his plea agreement by disavowing the factual acknowledgments he has sworn were accurate and true during his plea hearing. The state then argued that this witness had the opportunity at the time he took his plea to correct or clarify any statements in the factual acknowledgement before affirming their truth under oath. Yeah, they're trying to set him up before his probation ends. Miss Cutie Pie, I'm sorry. I'm saying I'm sorry because I have to agree with you. I do. I don't trust anything. Good morning, Elisa. Mr. Arnold has serious concerns that the state may, without any authority, attempt to do the same thing with Mr. Arnold. For this reason, Mr. Arnold wishes to advise the court in advance of his testimony why such an action by the state would be improper and illegal. As an initial matter, when Mr. Arnold attempted to correct or clarify the statements contained in his original factual acknowledgement, he was told if he did not admit to the statements as written, he would be sent back to the Fulton County Jail, held without bond, and be placed on trial with his co-defendants. Mr. Arnold continually explained that he could not swear to all of the statements the state wanted him to swear to in the factual acknowledgement. Notably, after Mr. Arnold was willing to return to the Fulton County Jail and stand trial, the state amended the factual acknowledgement to remove those statements for which Mr. Arnold had no knowledge. In other words, the parties specifically negotiated the scope of the factual acknowledgement to significantly narrow the potential scope of Mr. Arnold's testimony, which included a separate constitutional right to remain silent. We are writing to advise the court and the state outside the presence of the jury that if the state intends to call Mr. Arnold and ask him questions about facts that are not contained in his plea proffer or questions that are worded differently from the statements in Mr. Arnold's plea proffer, and then attempt to use those statements against him as it has with other witnesses or with another witness in an effort to revoke his probation, Mr. Arnold will assert his Fifth Amendment right against self-incrimination and will refuse to answer any such questions. Mr. Arnold's assertion of his Fifth Amendment rights, however, which was specifically contemplated by the express terms of his negotiated plea agreement, cannot be used to revoke his probation or to hold him in contempt. Come on. Yes. Oh my gosh. Oh my gosh. The contrast is crazy. Bonnie says, see what the state wants them to say and agree to, even if they want him to lie, then use against him. Yeah. Yep. Hey, hey, my big sis, Peaches and Cream. Good morning. Good morning. Okay. In addition, at no time between the date of Mr. Arnold's plea and the present has anyone from the state suggested to me that Mr. Arnold would be offered any immunity for any testimony he may give. Nonetheless, based on the state's history of using immunity to force additional witness testimony in the middle of trial, I outline below several issues for the court's consideration prior to Mr. Arnold taking the stand. Mr. Arnold has no faith in any immunity agreement that the state might put forth in this case and which has been offered to other witnesses to compel their testimony under the threat of incarceration without assurances from the court that this immunity will extend to the state's attempt to revoke his probation if they do not like how he answers questions. And let's go down to the reference that they have a reference. It says the grant of immunity may not be conditional, and therefore the state may not condition a grant of immunity on the testimony of the witness being full, complete, and truthful. Corson versus Hames. To be a valid grant of immunity, the state must make a written request and the court must make a specific finding that the witness's testimony was necessary to the public interest. The next part says, furthermore, Mr. Arnold has no faith that the state will not use whatever he says, no matter whether he has an agreement from the DA for immunity against him if they do not like how he testifies on the stand. Their reference or the footnote says the state recently filed a motion to revoke a witness probation because it did not like how that witness testified on the stand. The attorney was red hot caliente when writing this up. Right, Bonnie. The next part says Mr. Arnold's constitutional protections, much like a promise of immunity, ring entirely hollow when the state refuses to honor them. Let's go to that footnote. Where's it at? Hold on. I don't see number 3. Where's it at? 1, 2. Where's number 3? Child, I don't see her number 3 footnote. Okay. Go back up. With no guarantee that the state will not try to revoke Mr. Arnold's probation or charge him with another crime based on these same allegations or deny him bail or require he remain in unconstitutional conditions, Mr. Arnold will only answer the questions specifically negotiated and set forth in his proffer. In other words, he is asking this court to make the state honor its agreement with Mr. Arnold and not allow the state, as it has in the past, to change the terms only after it is unhappy with the testimony. I'm over here windmilling while you read. Come on, Shay B. To be perfectly clear, based on the express terms of his plea agreement, the state may only question Mr. Arnold to the following. Mr. Arnold is a member of the Rolling 60s Crips. Mr. Arnold became associated or affiliated with YSL in 2015, but not that YSL is anything more than a record label. Mr. Arnold committed the other incident for which he pled guilty to in indictment number 15 SC 140116, and again in 2022 in this indictment. Mr. Arnold committed the other incident for which he pled guilty, and again in 2022 in this indictment. Mr. Arnold was present on May 9th, 2022, when a search warrant was executed, and he does not claim ownership of any of the items the government claims to have discovered during this search. Mr. Arnold also acknowledged that YSL, which he knows is a record label, has the following identifiers: clothing with YSL or slime, pendants with letters YSL or slat, colors is green for slime, seen YSL members use one or more hand signs, language that members of YSL use includes slat, which means slime love all the time. Some of the language includes calling each other slime. Symbols that YSL uses includes a green heart and green snake. So he acknowledges their symbols, their hand signs, their color. But he says he did not say YSL was a gang. They are a record label. Hello, Republic Room. Welcome in. Welcome in. Thank you for subscribing. As explained above, as to any other topics or questions, Mr. Arnold intends to assert his right to remain silent under the Fifth Amendment. The Fifth Amendment protects Mr. Arnold against any statements that potentially could be against his self-interest. In the RICO indictment, the state has alleged that certain non-criminal acts were overt acts in furtherance of a conspiracy. Therefore, any statement by Mr. Arnold, even as to a non-criminal act, could be used by the state to demonstrate an overt act that could be used potentially to prosecute Mr. Arnold. In that scenario, Mr. Arnold would be forced to remain, yet again, in the Fulton County Jail without bond. Such an action by the state would be an obvious attempt to strong-arm Mr. Arnold into providing additional testimony, even though the state agreed to the terms of his plea offer, knowing full well to what Mr. Arnold could testify. Therefore, Mr. Arnold intends to assert his Fifth Amendment privilege against any making any such statements that are not covered in the agreed upon proffer, since any statement, as the state argues, can be used against him as an overt act should the state seek to use the information for that purpose. And he is asking this court to uphold the terms of his agreement and to decline any invitation to interpret his failure to testify to facts outside of that agreement as evidence of any probation violation that could be used to rearrest him. Every attorney that has people that still are going through or they have a plea agreement and they're going to have to testify for the state, copy and paste. You're going to have to cut out the parts if you did not negotiate some Fifth Amendment parts. But baby, still a lot of this on how the state not liking answers, baby, copy and paste and send the email to the state. Just get it on record. Good morning, Sharon. Oh, you are so welcome. Good morning, Brenda. All right. Let's see here. Did I shouldn't have scrolled up. It is also my understanding that many of the questions the state may wish to ask Mr. Arnold pertain to social media posts, musical lyrics, and videos, and friendships or associations he has. The state has denoted certain of these facts as overt acts and continues to argue that other acts are admissible as overt acts in furtherance of the alleged conspiracy. Therefore, Mr. Arnold intends to assert his Fifth Amendment privilege for any questions about social media posts, musical lyrics and videos, and his friendships or associations, since none of these topics were listed in his plea proffer. Despite the foregoing, Mr. Arnold wishes to make certain that he intends to fulfill the requirements of his plea agreement and testify as to the matters outlined in his proffer and summarized above, but only those topics. Mr. Arnold wants to make abundantly clear that based on his fear that the state will seek to revoke his probation should the state seek testimony beyond that in his proffer, he only intends to respond to those specific questions, and only if they are worded in the same manner they were posed during Mr. Arnold's pre-proffer. If the state intends to inquire into any facts beyond the scope of his plea proffer, Mr. Arnold is providing the court and the state with notice that he intends to assert his right to remain silent, a right he specifically protected in his plea agreement. Okay. I trust this history of the negotiations regarding Mr. Arnold's plea and summary of Mr. Arnold's position on recent issues that have emerged in the context of other witnesses will assist the court in evaluating these issues should they arise during Mr. Arnold's testimony. We happily invite the state to outline its position for Mr. Arnold, the court, and the current defendants so not just she's not even keeping this just to her client. She said that I'm going to read it again. Hold on. They happily invite the state to outline its position for Mr. Arnold, the court, and the current defendants so that everyone is on the same page before Mr. Arnold's anticipated testimony so as to ensure his testimony can be taken expeditiously, fairly, in accordance with the terms of his negotiated plea, and without a violation of Mr. Arnold's Fifth Amendment constitutional rights. Should the court wish to hear from Mr. Arnold on any of these issues in advance of his testimony, I am happy to address them at the court's pleasure. Let's go. And CC'd was Adrian Love, Adam Abadi, and the defense counsel. Baby, that's how you do it. Republic Room said Ashleigh's emails and letters are so timely. What happened to Moonk was pretty despicable. We just went over that. And I feel like the thing that got Moonk the most was when his probation officer came up. Hey, Don Don, because we heard some stuff that we didn't know about. I was like, ouch. But I still maintain that the system is not set up for people that he actually was admitting to the stuff that he was guilty of, but they were strong arming him to admit stuff that he did not agree to as well. And I don't like what I won't revisit it, but a lot I don't like and I don't think is right. Yes, CC, this is the type of legal representation you pay for. I need an attorney like Merchant, Weinstein, Shart, the woman that sits by Shart. They don't say her name a lot, so that's the only reason I can't remember, because I would say her name when I can start remembering it. The one that tells a body to use his mic every other day. I need those types of attorneys if I ever need help. Right. Well done. Okay, y'all. So as I was telling the others when they were in here earlier today, we have a lot of lives today because I want to read the prosecution asking the court to reconsider Dennis's testimony staying in. I want to read that. So we will have a lot of lives today. We have recaps today. So Republican said exactly, you are right. That attempted aggravated assault was alarming regarding Moonk. That's where we were. You're on the same page as us, Republic Room. That's where we were like, what now? Same thing. Yeah, 5 years instead of 27.5 years is a favor. It is. That is very, very true. I agree with you. Okay, y'all. So I'm going to see y'all again soon. Please keep your notifications on. Refresh the page. I will be back a lot today. All right. Thank you. And shout out to my new subbies. I appreciate y'all. Thank you, Republic Room. See y'all soon. Oh, hold on. Sharon said Love and her posse had it in for him because he was confrontational with them. Yes. Y'all make sure you go vote. Yes, it's early voting season. Yes, please go vote. We should be voting this week coming up. Yeah, Bonnie said that's why I said nope. Right. Okay, Shay B, come back, y'all. All right. Bye.